to the criminal justice panel, Beyond Profiling. We're happy to see you here today. We have a terrific panel for you. I'm going to introduce the topic and introduce our panelists. As for our topic, well, first I guess maybe I should introduce myself. I'm Carol Steiker. I'm one of the co-chairs of the Criminal Justice Issue Group of ACS. I'm on the faculty at Harvard Law School. And I write and teach in the area of criminal law and procedure, capital punishment, criminal justice issues generally. And I think it's safe to say, excellent, our fourth panelist arrives just in the nick of time. I think it's safe to say that no one who even casually observes the American criminal justice system can miss the racial disparities that are evident in all aspects of it. When you start with policing, the experience of differential experiences based on race and street and highway encounters is well documented. The differential policing of entire communities, the differentials in the use of force and particular police tactics have huge racial disparate impacts in terms of prosecution, the differentials in charging and plea bargaining. Certainly sentencing differentials were one of the factors that led the left to join the right in promoting federal sentencing guidelines and guidelines in various state systems that sense that there were racial disparities among other disparities in sentencing. The differential impact of the collateral consequences of conviction given the differential rates of incarceration based on race, and some of the most important, but by no means all of those consequences include disenfranchisement and even deportation. Differentials in the juvenile justice system and how young people are treated generally in the criminal justice system. And we shouldn't forget the differentials in victimization and crime rates in areas based on racial composition, and the sense that there's not only to some extent racial over-enforcement, but racial under-enforcement of police protection and resources in different communities. So these disparities have had enormous consequences, not just for the many individuals whose lives they've touched, but for entire communities. And the questions for this panel are, how exactly do these disparities get created or become the product of our criminal justice system? What mechanisms are at work? And equally, more important, how to address these disparities in the criminal justice system. And those questions can range from whether the answers should be primarily within the criminal justice system, that is, changes to our institutions of criminal justice, or outside of it, would changes in, for example, patterns of residential segregation or educational segregation be a better answer, a more effective answer than changing the structures of police departments or prosecutors' offices or sentencing law. And then when you look inside, if you think that at least some of this change has to come within the institutions of criminal justice, where exactly which institutions are the best locus for change, and how ought that change to occur? And when you start to talk about tactics of change, the one obvious question among many is, given that the problem is racial disparity, is the answer some kind of race-conscious answer, or answers in the general structure that are race-neutral but that will affect the disparities that we see along the lines of race? So these are just some of the questions that the panelists that we have for you address in their work and will address to you and to each other today. We have an absolutely terrific panel for you, and I'm going to introduce them and let each of them speak briefly, and I will perhaps pose some questions to them and open the floor for your questions to this panel. So immediately to my left is Vanita Gupta, staff attorney at the American Civil Liberties Union, where she works on issues relating to criminal defense, immigration detention, and the so-called school-to-prison pipeline. Before she was at the ACLU, Vanita, I'm taking my cue from Elena this morning, I'm going to call everyone by their first name. If that's all right. None of you have all that fancy titles like the rest of them. Before Vanita was at the ACLU, she was assistant counsel at the NAACP-LDF. She's worked on several very high-profile cases, which if you have not heard of her, which many of you have, you will have heard of the cases that she worked on. She successfully led the effort to overturn the convictions of 38 defendants in Tulia, Texas, organizing over a dozen national law firms and coordinating the legal and media strategy. She also represented and won the freedom of prison journalist Walter Rideau in his 4th trial after he'd already spent 44 years in Louisiana State Penitentiary and became there a famous journalist, as well as probably its most famous released convict. She's won many awards and all kinds of fancy things, but we're going to move on. That's next to her is Kurt Levy, who's the executive director of the Committee for Justice. He has served as the director of legal and public affairs at the Center for Individual Rights, where he worked on Supreme Court cases involving affirmative action and federalism. Most recently, he headed the Title IX policy group at the U.S. Education Department's Office for Civil Rights. So far you might not be able to tell, he is our Republican on the panel.
Or at least you're conservative.
He's our conservative. All right, you're right. It's the prior panel was clearly Democrat-Republican. Here it's going to be liberal-conservative. And this is the thing that will give it away. He's on the executive committee of the Federalist Society Civil Rights Practice Group. He is also someone you very well may have heard of. His op-eds have appeared in many national legal publications. He's been a guest on more than 100 radio and television programs and has spoken to dozens of live audiences, including many of the law schools that many of you go to. Interestingly, this was a fact I didn't know. He has a master's and a BA in computer science and has worked in the field of artificial intelligence and invented a new type of AI technology for which he wrote a successful patent application. So a man of many talents, but
or easily gets bored with it.
Yeah, that too. Angela Davis on Kurt's left. Angela is a professor at AU's Washington College of Law here in D.C. and is an expert in criminal law and procedure, and with a particular focus on racism in criminal justice system and prosecutorial power. I think her most important job was as the director of the D.C. Public Defender Service, where she was my boss. She's also served as the executive director of the National Rainbow Coalition. What's wonderful is Angela's recent book, Arbitrary Justice, The Power of the American Prosecutor, has just come out from Oxford University Press. So she in particular is interested in how prosecutorial power contributes to the racial disparities in the American criminal justice system. And she can talk about that and her book. I'll do my Oprah thing today. Now, if I had David's book, his most recent book, I'd do that too, but he didn't give me one. To Angela's left is David Cole, also professor of law at Georgetown here in D.C., and he's also has been for many years a staff attorney for the Center for Constitutional Rights. He's also the legal affairs correspondent for The Nation and a commentator on NPR's All Things Considered, and a frequent author in the sort of popular highbrow press, and the author of many books. Some of you may be familiar with his books, Enemy Aliens, Double Standards and Constitutional Freedoms in the War on Terrorism, No Equal Justice. This is probably the most relevant for the purposes of today's talk. No Equal Justice, Race and Class in the American Criminal Justice System. And his most recent book is Less Safe, Less Free, The Failure of Preemption in the War on Terror. Like like all of our panelists, they've all won many awards, which I'm going to spare the reading of, but just to say they may not hold high political office, but they're a very fancy panel and a panel with great expertise in this area and a variety of views and perspectives. So I'm going to open by asking Vanita to speak.
Great. Good morning. I am a full-time racial justice advocate. I've represented criminal defendants in their habeas proceedings, and I litigate civil challenges to the criminal justice system to attempt to reform specific aspects of it, mainly through indigent defense. And being a racial justice advocate in the climate of today's courts is not easy, and I think that there are a lot of ways of looking at racial justice work in the criminal justice system. It isn't always about making equal protection challenges in court, frontal challenges to address racial disparities in the system. I think that those today generally are not successful, certainly in the federal system, but there are some state courts and state constitutions that have much meatier equal protection clauses. But we are litigating in the legacy of McCluskey v. Kemp, infamous in my mind Supreme Court case, one of the most tragic cases in the 80s, where Justice Brennan rightly called it that the Supreme Court had a fear of too much justice when incredible statistical analysis was done to try to establish racial disparities in the administration of the death penalty. And really that decision would have had enormous consequences on all areas of the criminal justice system, because all areas, as Carol pointed out, are infected with racial bias in the criminal justice system. But the legacy of McCluskey has been one that has really hurt criminal justice reform advocates' ability to provide and bring some kind of try to bring equal justice back into the system. There have been a lot of national groups in the last couple of years strategizing and trying to strategize about ways to potentially reopen McCluskey. And frankly, and call me a cynic, but given the Supreme Court, I don't think that there's any way that that would happen, and I'm not even sure that I would want us to try. But the problem with McCluskey and the problem with trying to bring equal protection challenges in this day and age to bring remedies to the criminal justice system is that it requires proof of intentional discrimination, as all of you know, and proving intentional discrimination is incredibly hard. The statistics are astonishing, and I don't want to spend any time talking about those statistics, because I think those are things that generally get talked about at conferences all the time. I think that the goal here today is to try to think creatively about what else can be done in light of the current climate. The reason why proving intentional discrimination is so difficult in this day and age is that so much of what goes on in the criminal justice system involves unconscious racism. It's unconscious on the part of police. It may be unconscious on the part of prosecutors. I'm not saying all of it is. In fact, the Tullier, Texas cases, I think, were an example in which intentional discrimination was actually quite easy to prove. But those cases are not very common. And so I think that we don't need to be just thinking about, I guess, racial profiling and its link to equal protection challenges, because those are incredibly difficult to bring. I do think, though, that because of the population that is in the criminal justice system today, one that is predominantly black and brown, and because of the overlap in this country of race and class, progressive reform efforts in the criminal justice area are never race neutral. You don't have to be bringing equal protection challenges. You don't even have to be talking about race head on. When I litigate indigent defense issues, and we try to, and other groups try to institute statewide public defender systems in various states, that is a very race-conscious effort because of who the population is that will be most greatly affected by those kinds of efforts. And so I think that, to call any kind of reform in the criminal justice system race neutral is a big misnomer, and I just don't think that even it doesn't even make sense to me, frankly. I think that there are a lot of ways to challenge racial inequity in the system. Some of it, as I just mentioned, involves looking at indigent defense and the way that indigent defense is actually meted out. There are way too many states in this country, the world's wealthiest nation, that do not have statewide public defender systems, and it creates a real problem of unequal justice for the poor. One of my heroes, Brian Stevenson, always says that it is a lot easier in this country to be rich and guilty than it is to be poor and innocent. And I think you could go to any courtroom in any part of the country, big city, small town, rural town, where that will be proven. I'm currently litigating a case in Michigan, Michigan has a patchwork of indigent defense systems in each county. It's run by the county. The state doesn't put in a single dime into funding that system. And literally every county in Michigan has a very different way of administering indigent defense. And it creates, there's a tremendous impact on the way that people of color receive, indigent people of color receive defense in the state of Michigan. Police misconduct is another area, prosecutorial misconduct, which Angela Davis is going to talk about. And obviously a lot of the legislative work that's going on right now, which I think is very positive, around sentencing reform and reentry issues. I tend to look at successful criminal justice reform as sometimes, I tend to look at criminal justice reform as sometimes being more successful if it actually focuses on what I call retail cases versus wholesale cases. I think there are a lot of criminal justice policy often gets pushed through because of terrible stories of crime. You'll get one specific or two specific stories which galvanize the public imagination, which push legislators to really act. You end up with things like Megan's Law, 3 strikes, 0 tolerance, very highly publicized cases that can often push the law into very punitive areas and can have a breadth that is excessive and that ends up being very disproportionate to your average criminal activity and so I think the progressive movement needs to really look at retail cases, and I think the innocence movement, while I have a lot of issues with innocence as kind of leading the way, but it has a certain kind of salience to galvanize people, to tell stories about the ways in which people of color can receive unequal justice and can push reform in the other direction to be more to try to increase the access to courts for people of color. The Tulia, Texas cases, I think, is just one example of that kind of case, but I think a lot of reform often is done through storytelling, and the power of telling a story and pushing legislators to make reform I don't think can be overstated. There's a new area of, and I'm just going to speak briefly about it and then pass it on, that a lot of national civil rights groups are currently working on, the ACLU, the Legal Defense Fund, and it's around school-to-prison pipeline issues. And to me, it's another area kind of on the front lines, I think, of civil rights work right now that ultimately, I think, has big consequences on the criminal justice system and who's going in. And this really involves the criminalization of youth and public school students in public schools, where more and more children are being singled out and removed from mainstream schools for very minor disciplinary infractions and placed on a one-way path, literally, out of school into alternative schools or straight into the criminal justice system, ultimately yielding the kinds of statistics that we see where there's such a high school dropout rate. I can't remember I think it's 67% of all men in prison don't have high school diplomas. You can see the pipeline very much at work. There's an increased presence in the last 10 or 15 years of police in the schools that have disempowered school administrators from dealing with incidents at schools as school discipline problems. There's no question that there is, people need to be mindful of the violence that goes on in schools, but to use minor infractions, where now you're seeing in Florida and in other states around the country, 6- and 7-year-olds getting arrested by police officers. What I worry about is that today we may be talking about individual incidents like that, but we are seeing them increasingly on the rise, and the ages of children getting arrested for minor infractions is getting younger and younger. And of course, this has a huge racial dimension. This is affecting mostly black and brown students in the public schools. And there's all kinds of ways in which reformers are challenging this. I'm just going to list them out very quickly. One is to challenge the push-out phenomena, which is really encouraged by laws like No Child Left Behind, which creates incentives in the schools to get rid of kind of problem children, where, through increased presence of law enforcement in the schools, children are being pushed out that are considered problem children and then placed into alternative schools. I'm now doing an investigation of alternative schools in Mississippi, and it is shocking to me what I'm seeing in these alternative schools. I mean, these are not educational facilities at all, and sometimes kids are going there for 30 days. Sometimes they're told to they're expelled and told go there for a year. And there's really very little education that's happening in these schools. It's a huge scam as far as I'm concerned, and there's a whole invisible population of high school kids that are being subjected to these so-called schools. And there's no question in my mind that there is a direct line to the prisons from these schools. Many of these children end up dropping out. And so another area of challenge is really challenging the quality of education in alternative schools. There's a whole private alternative school industry that mirrors a lot of the private prison industry, and there's a lot of work to be done in that area. There's also people working on ensuring the reentry of these children back into mainstream schools after they've either been adjudicated delinquent or even placed into alternative schools. Because of NCLB and a lot of other incentives that are created for schools to push and keep certain kids out, there is an unwillingness on the part of a lot of mainstream schools to accept these kids back in, even though they have a right to be in. And again, children get lost that way. And so these are just some different areas of work, and I think there's often a confluence of very highly publicized incidents that create criminal justice policy. There are now more and more highly publicized incidents of very tragic school-to-prison pipeline cases. I don't know how many of you have heard of the Shaquanda Cotton case in Texas. There's been a number of Florida cases, and where there are one of the good things about school to prison is you can find a white kid comparison that shows a very different disciplinary response. It takes a lot of statistical analysis. The ACLU just settled a big case in South Dakota involving a very big statistical analysis, but the disparity of treatment of Native American children in a rural school district, and it's a huge problem. And so I think that despite the courts and how conservative things are going certainly in the federal court system, that there's a lot of different avenues to do work that addresses racial inequities, and that none of these efforts are race neutral, and actually all of them are efforts at bringing racial justice back into the system. Thank you.
Thank you, Benita. Kurt.
Well, first I should point out that when I was invited to take part in this panel, one of the reasons that I wanted to was the presence of Professor Steiker as the moderator. She taught me criminal law in my 1L year in law school, so I thought
I
it would
was
be
11 at the time.
That's right. And I was 8, so. As Professor Steiker pointed out, I'm here to represent, I guess you'd say, the conservative point of view. Not your fault, but I found it that way. But, I guess, in the interest of full disclosure, I'm probably not so much a traditional conservative as I am a libertarian, say, with a conservative bias. But I'm somewhat torn on this issue of race in the criminal law because I as a libertarian, I tend to have, say for the most part, liberal views on the criminal law, but views that would be called conservative on race. I mean, in fact, I was one of the attorneys, when I was at the Center for Individual Rights, I was one of the attorneys representing Barbara Gruder and Jennifer Gratz in the University of Michigan cases. And I should tell you, as I was preparing this talk, I strayed more and more away from what we had talked about, so hopefully don't get scared. I should also point out, in the interest of full disclosure, that my expertise is in civil rights, rather than in criminal law. And so when I accepted this invitation, I set about, reading some of the literature on race and criminal law. And, I've always believed in the proposition that government should be colorblind, and a lot of the work in this area argues the same thing, certainly not all of it. So, it's hard for me to critique a lot of the liberal writings in this area. The thing that I kept noticing is that a lot of the best arguments against things like racial profiling were similar to the arguments that I typically make when I'm arguing against race-based affirmative action. And so in the end, I decided that I wanted to talk about the parallels between racial issues in the criminal law and the debate over affirmative action. And, particularly because of my own involvement in it, university admissions. My goal here is to provide a different perspective, of course, and hopefully make you think. This is in no particular order, but one of the parallels I saw was it struck me how much race and poverty are conflated in both debates, the affirmative action and debate and this debate. I think in both cases it's a lot sexier to talk about race than income, and of course there is a correlation, a strong correlation even, but I think conflating the two can be very misleading. I think one of the most profound things that I got out of law school, specifically the clinical program I did, was a realization that justice for the poor is really not even in the same universe as justice for those who can afford to hire good lawyers. I will never forget when I was, I'd like to think that those of us in the clinical program at least gave a damn. We might not have had any expertise, but we at least gave a damn, and that certainly wasn't what I saw from most of the court-appointed attorneys. I will never forget when I was overheard one of the court-appointed attorneys saying to the defendant as they walked up to see the judge, "Remind me again what you're charged with." So, I would contend that the problems of being poor in the criminal justice system really dwarf the problems of being a minority. As an example, I noticed that the literature in this area is filled with the assumption that the interaction that minorities, particularly African Americans, have with the police is just a whole different world than the type of interaction that white people have with the police. For example, it's used to explain why what might seem like consent, if you have a friendly relationship with the police, really isn't consent, isn't voluntary, I should say, if you have if you're, say, living in the inner city. But again, I think, and it's often posed as a racial issue. To me, it's really about living in the inner city. People living in an upscale suburb and wearing business suits typically have a dramatically different interaction with the police, regardless of color, than do people living in the inner city. To make the parallel with admissions, you often hear the argument that you can't expect a black kid who risked his life just to walk home in the inner city to compete under the same standards as a white kid whose parents paid for after-school tutors. That's true, but it's really an argument about income. It's a bad argument to justify race-based admissions. Even Bach and Bowen, in their famous book Shape of the River, pointed out that about 70% of the minority kids benefiting from affirmative action were middle class or affluent. Another thing that struck me was a tendency to really equate disproportionality and discrimination, with no more evidence than just the disproportionality. Certainly, disproportionality can be a sign of discrimination and merits looking further, but the literature reminded me of the arguments for race-based administration by often equating the two with little more. There's an underrepresentation of minorities, therefore, in the admissions context, therefore they're discriminated against. And the converse argument in the criminal law. But of course, if disproportionality were proof of discrimination, we'd have to conclude that the criminal justice system is probably most dramatically discriminating against men. Men are stopped, searched, arrested a lot more than women. Juries are typically less sympathetic to men. Men get longer sentences for the same crimes, but I don't think anyone really thinks it's because of systemic bias. The truth is men are more likely to commit violent crimes, and that's not politically incorrect to say. It is politically incorrect to say that blacks and Hispanics are more likely to commit violent crimes, but I also sadly think that it's true. I mean, even Randall Kennedy has called the evidence of that overwhelming. Of course, that doesn't tell us why, and there's no doubt a myriad of social factors involved, but to me the really interesting question is whether the criminal justice system should be able to rely on that fact in how it approaches a young black male, or whether it should be able to rely on the fact that most terrorism these days is Islam inspired. Should you be able to rely on that in how you approach a Muslim male at the airport? That to me is the tough question, and I think often the emotional answer is, yeah, you should be able to rely on that. It's ridiculous to search the the old lady at the airport, to the same extent that you're going to search the young Muslim male, and there is an argument for that. But in the end, I just think it's too dangerous a road to go down. You have to give up the benefits because it's just too dangerous a road to go down. And again, there's very real practical benefits to heightened scrutiny for young males, be it black on the street or Muslim in an airport, and there's very real benefits to diversity. We can debate whether it's compelling or not, but clearly there's benefits to diversity in the admissions context. But I think if the Equal Protection Clause gives you an individual right, as the Supreme Court has certainly said it does, then it shouldn't matter whether your race or your gender or whatever has a heightened probability of committing crimes or of bringing a unique perspective to the classroom. That simply has to be ignored. A related argument is that you shouldn't have to pay for your brother's or your sister's sins. If we put the diversity rationale aside and look at the proportional representation, social justice rationales for race-based admissions, then the reason that Jennifer Gratz, the argument would go, has to give up her seat at the University of Michigan is not because she did anything wrong, of course, but because other white people did things wrong in the past, and because too many white people have the grades and test scores to get in. I mean, the typical argument is, what are you complaining about? There's already plenty of white people there. But if you buy that, it doesn't require much of a leap to say that a young Muslim man has to endure more intrusive searching at the airport because Muslims commit terrorist acts at a much higher rate, or that an African American has to endure more police suspicion because other blacks are doing something wrong, i.e. committing crimes at a relatively high rate. I would argue that you should support Jennifer Gratz's right to be viewed independent of group characteristics exactly because you want the same for the young black or Muslim man. To put it in a strict legal context, when you allow strict scrutiny to be weakened, as it was in Grutter, it imperils us all. If being denied admission is not too high a burden for the benefits of diversity, then certainly being delayed half an hour in the airport is not an acceptable burden for preventing the extraordinary number of deaths that can occur from terrorist acts on airplanes. I would argue that in the end, though, neither is okay. I would agree with, as Chief Justice Roberts put it in the recent Seattle-Louisville cases, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And it's not just conservatives who say that. Randall Kennedy in the criminal context has said, and I'll quote, "The uncompromisable ideal of treating all persons equally, regardless of race, is an inspiration best sought by responding to persons strictly on the basis of conduct, not color." I just think that's true whether you're talking about admissions or searching people at the airport. You can come up with lots of arguments about why racial distinctions benefit society, but in the end, there's only one way we're going to end discrimination, and that's to stop discriminating. I should probably stop there because I've gone on long enough. Thank you.
Okay, thank you, Kurt. Angela.
Okay, I'm going to resist the urge to respond, and I'm going to stay on message, but I'm going to make 2 points first. African Americans don't commit drug crimes at a higher rate than whites, and that's the crime for which for which cops racially profile the most. So that's the first point. And second point is I want to introduce you to all of the judges, lawyers, doctors, and law professors, and other middle-class black people I know who've been stopped and harassed by police officers, and then you can tell them that race doesn't matter. Now I'm going to talk about what I was supposed to talk about, which is prosecutors. A lot of attention has been paid, and rightly so, to the role that police officers have played in producing these racial disparities we have in the criminal justice system, to the sentencing laws, such as the disparity between crack and powder cocaine, and that attention is well deserved. But almost no attention has been paid to the role that prosecutors play in creating those disparities or contributing to those disparities. And prosecutors do play a role, a very significant role. They have to, because they're the most powerful players, most powerful officials in the criminal justice system. The charging and plea bargaining decisions are the decisions that drive the criminal justice system, almost predetermine the outcome of criminal cases, when you consider the fact that over 95% of all criminal cases are resolved by way of a guilty plea, and prosecutors make that decision and don't have to justify the decision to anyone. That is the decision whether to charge, what to charge, whether to offer a plea bargain, what to offer. Those decisions are totally within the discretion and power of the prosecutor. And they don't have to justify the decisions to anyone other than other prosecutors. And so when you consider that important role that they play, again, I think the most important role in the criminal justice system, of course, they have to be contributing to the racial disparities in the criminal justice system. I don't contend that prosecutors intentionally or even consciously discriminate in the criminal justice system. I agree with Vanita. The Tulia situation is an extreme one. I don't think that prosecutors do, but I think that the role that they play in contributing to these disparities is a very complicated one. And I want to talk about just two issues. One, Vanita already mentioned, and that's unconscious racism. Unconscious racism, you know, is what we all suffer from. Charles Lawrence, Professor Charles Lawrence at Georgetown wrote the seminal article, and I think it's called The Id, the Ego, and Equal Protection. Unconscious Racism, the Id, the Ego, and Equal Protection, I think is the title of that article. I commend it to you. But it's that thing we all suffer from, right? It's the thing that makes, you know, people cross the street when they see a young black male or clutch their bags a little bit closer. It's the thing that makes me cross the street when I see a bald-headed young white kid with tattoos. You know, it's that unconscious thing that makes you sort of just, you know, fear the other or think that other person is criminal. And we're not even aware of it. And everybody, including prosecutors, suffer from it. And it's very significant for prosecutors, however, because they have all the power. And so when they act based on this unconscious racism, it has tremendously difficult and sometimes unfair results. It's that thing that makes the prosecutor look across the courtroom at the white kid who's, you know, college bound and got a great future and feel a certain empathy and remember when they used to do drugs in college and think, you know, let me give this kid a break, and look across the courtroom and see a young black kid and not see a future and not feel that empathy. And it's not even a conscious thing that they're doing, much less an intentional thing that they are doing. But it affects these decisions that they make every day about whether to charge, what to charge, whether to offer plea bargain, whether to divert. And those decisions have monumental, permanent effects on individuals when you consider just even the presence of an arrest record, much less a criminal record, much less incarceration. And so there's that point. There's also, however, an even more complicated issue, and that is the racial effects of the so-called, apparently so-called, race-neutral decisions that prosecutors make every day. I think Vanita touched on this a bit. That is, prosecutors make decisions every day in terms of what to charge and how to charge that appear to be race-neutral, but when you look at them a little closer, they aren't. Or I should say maybe they are race-neutral, but they have a tremendous race effect. And these factors that they consider in making these decisions every day are not, they're factors that I think all of us would probably say are okay. You know, they are in fact sanctioned by the American Bar Association and in its prosecution standards. That is, the standards that are written and established for prosecutors to follow. There are also standards for defense and so on. And prosecutors, the standards are not mandatory. They are aspirational. I doubt quite seriously whether prosecutors even think about them when they make their charging decisions, because I think they make them quite arbitrarily, as my book discusses oftentimes. But, for example, the ABA says that prosecutors should consider a variety of factors when making charging decisions, factors like the seriousness of the offense, the interest of the victim in prosecution, the likelihood of conviction. When we look at all of those race-neutral factors, we can say, yes, those make sense. Makes sense for a prosecutor, for example, to consider the seriousness of the offense, to not perhaps prosecute a simple assault where no one was injured, but to prosecute an aggravated assault where there are injuries. It makes sense that one would prosecute the more serious offense. The interest of the victim in prosecution. It certainly makes sense for a prosecutor, for example, to take into consideration a victim's desire. It's not a determinative factor, but if a victim does not want to go forward in the case, it's a a neighborhood fight, no one was injured, they want to work it out with their neighbor, and they say, look, I don't want to go forward with this, it makes sense for the prosecutor to say, fine, with the few resources that we have in the criminal justice system, I'm not going to pursue a case the victim doesn't want to go forward, especially if I don't think this person poses a danger to the community. But even a factor like that can have racial effects. Consider, for example, I'm a busy prosecutor, let's say, and I've got 2 burglary cases in my docket of 80 cases, and one involves a white victim who is going to more likely be middle class because of the relationship between poverty and race, which I'll save for later, is more likely to be white. That victim, let's say, shows up for the witness conferences, comes to the grand jury, is well-dressed, is articulate, clean and articulate, makes a good witness, is on time, and wants to go forward with the case. Well, of course, I'm going to be more likely to prosecute that case than I am the case involving the poor, most likely black or brown victim whose apartment has also been burglarized, who doesn't show up at all for the witness conference, and I got to chase them down, and they're not showing up, or if they show up, they're not able to really make a good witness because they're not dressed properly and they're not articulate, and I got to spend all this time working with them to make them presentable to the jury, etc. Maybe, or if they don't show up, I may assume they're not interested in prosecution. Maybe they are interested, but they didn't get their mail because they never get their mail because in the apartment building where they live, they don't get mail. Or they got the notice, but they can't take off at 2 o'clock in the afternoon from their day job or they'll lose it. Or they're afraid to come down to the prosecutor's office because that's where their kid was prosecuted, or whatever. And so it's a complicated issue, and you sort of don't, what do you expect the prosecutor to do in a situation like that? But it certainly does have racial effects, without a doubt. And of course it affects other factors like the likelihood of conviction. We don't want prosecutors to go forward in a case when it'd be unethical for them to go forward when they know they're not likely to get a conviction, to put put the defendant through that, to put the victims through that. But then again, all these other factors affect that one too. That is, I'm more likely to get a conviction if I've got a clean, articulate, well-dressed, well-spoken victim that's going to appeal to the jury. It's going to make it more likely that I'm going to get a conviction. So they're complicated. They don't appear to have racial effects, but they don't appear to be race issues, but they are race issues, right? As Vanita pointed out, I mean, race is just infused in the system. So how do we fix it? Do we ignore that and just go merrily along the way? I don't think so. The problem is that there are no legal remedies. I say no legal remedies. Vanita says they're difficult. Okay, they're difficult. I just think they don't exist. When you look at McCleskey, when you look at Armstrong, another case that if there's time later I'm happy to talk about, a whole slew of cases, particularly the ones that deal with prosecutors, from Oler v. Bowes to Waite to McCleskey to Armstrong. the court requires proof of intentional discrimination, and there's language in all of those cases on top of that, on top of the equal protection analysis, that sanctions the power and discretion of prosecutors and their freedom to make these decisions freely. And the court has protected that and continues to protect it. So we don't have legal remedies, so what do we do? Reform is absolutely necessary. I think I'm encouraged because I do think that there are some reform efforts going on out there. I'll mention two briefly and happy to talk about them later during the Q&A. One is a project called the Prosecution and Racial Justice Project, sponsored by the Vera Institute, in which 3 prosecutors, chief prosecutors, are opening their prosecution offices to allow Vera to do the kind of statistical study that Baldus did in McCleskey, basically to determine whether or not their race-neutral decisions are having a race effect. I think it's a bold thing that these prosecutors are willingly doing. And that's the beauty of it, right? I mean, the Supreme Court's given all this power to prosecutors, so we don't really need, we don't need laws or anything. We just need prosecutors to have the will on their own to make changes in their policies and practices to have an effect on this. And I think that can take us somewhere. I'm also involved with the ABA's Commission on Effective Criminal Sanctions, and that commission has recommended race and ethnic task forces in which the chief players in the criminal justice system, including and especially the prosecutor, who's the most powerful, but the chief defender, the chief judge, the chief probation person, community, all come together and determine along the way, at each step of the process, where are the decisions that these players and officials are making, the discretionary decisions, where and how are they having a racial effect? To try to become aware of that so that they can then make necessary changes, of course consistent with the fair administration of justice, to try to eliminate these disparities in the criminal justice system. So I'm happy to talk about it and would hope to have the opportunity to talk about that more during the Q&A, but I'll stop for now.
Thank you, Angela. David.
Thanks. When I teach my criminal justice class at Georgetown, it's essentially a course about race and class disparities. It's a course that tries to demonstrate that at every stage of the criminal justice system, the system is in fact predicated on the exploitation of double standards based on race and class. So this year, when I was writing my exam for criminal justice, I thought, well, let me try to make the students think rather than just parrot back what I say to them. So I asked them to defend the proposition that there are good reasons why the courts have not remedied race and class disparities in the criminal justice system. And lo and behold, they wrote some very good, strong essays and came up with all sorts of good reasons why the courts have failed to remedy race and class disparities in the criminal justice system. The necessity for discrimination, the necessity for discretion, and the difficulty of regulating discretion. The difficulty of proving motive and discrimination, particularly when the problem is largely or often unconscious racism. Institutional limitations on the judiciary. The effects of private property and capitalism on the ability to equalize, for example, the right to counsel. These are all familiar arguments, and they were familiar, I realized, because instead of parroting what I'd told them during the course of the year, they parroted what the Supreme Court said in McCleskey and Armstrong and Wren and in all of its cases. So I guess my mistake was thinking that an exam is actually an opportunity to think. But these are, I think, significant hurdles. They are significant hurdles, and yet we're left to ask: can we accept a system in which, at current rates, 1 out of every 3 black male babies born in the United States today will spend time in prison? We certainly would not accept that state of affairs if 1 out of every 3 white male babies born today across the country would expect to spend time in prison. So why should we accept it for African Americans? Nonetheless, I think when one combines the kinds of considerations that my students put forward with the conservative trend on the court today, the courts are going to be a very difficult place to get much relief. This is, I think, inexcusable. I think courts have a particular obligation to ensure that justice is done to the most disadvantaged, and that courts have a particular expertise in overseeing criminal justice disparities over and above their expertise in overseeing disparities in, for example, school systems. But nonetheless, that's the reality that we confront. And, you know, I could stop there, but I don't want to. I was at a conference a couple of years ago. I'm sure Carol would be happy if I stopped there. But I was at a conference a couple of years ago at Berlin where an Israeli philosopher was speaking about the war on terror, and he gave a very, very grim talk. You know, as many of the talks you've gone to, I'm sure, over the last 2 days have been grim. And he ended by saying, you know, well, were I an American or in America, I would feel the need to end on a note of optimism. But I'm an Israeli, and I'm in Berlin, so I'm done. But I'm an American, and I'm here at the American Constitution Society. So I want to talk about positive areas of reform. And I think I want to do so not just to end on a note of optimism, but also to sort of think about what is it about these areas where there has been positive reform that has, in fact, I think, been to the advantage of African American and poor citizens in this country. What's driving it? So I'm going to talk about 5 areas of progress very briefly. The first is alternatives to incarceration, and in particular where this has played a role is in the war on drugs, which of course is responsible for much of the prison boom in the last quarter century. From 1979 to 2005, the U.S. incarceration rate tripled, and we surpassed Russia, so we are the highest. We have the highest incarceration rate in the world. Drug offenses during that time went from 6% of those imprisoned to 25% of those imprisoned are imprisoned for drug offenses. So one way to reduce the prison population is diversion, to favor treatment over incarceration, and that is it has been movement in the last 10 years in that direction. Drug courts, for example, which provide a kind of coerced treatment as an alternative to incarceration for drug offenders, have gone from a handful 10 years ago to nearly 2,000 across the country today. So that's one, alternatives to incarceration. The second is sentencing reform, reducing mandatory minimums, reducing sentences for nonviolent offenders, and the like. Between 2004 and 2006, the last 2 years, 22 states, according to the Sentencing Project, adopted legislation or executive reforms that reduced incarceration and time served. New York softened its notoriously draconian drug laws in 2004. Connecticut eliminated the crack cocaine disparity in 2005. Over the last decade, California reduced its youth prison population by 75%. Over the same period, Texas increased its youth prison population by 50%, and they have the exact same offending rates in California and Texas. So California is reducing the prison population by 75%, did not in any way increase offending there. The third are reentry programs, and here I like to think of this as kind of the rehabilitation of rehabilitation. We gave up on rehabilitation somewhere around 1970, but it's coming back. And 2 arguments are made for why it ought to come back. The first is because we've put so many people in jail, they're virtually all going to come out at some point, and so we've got increasing numbers coming out, over 650,000 coming out of jail and prison in 2004 alone. Many of them will be returning to prison based on current rates of recidivism. We need to do something to reduce recidivism. And the second argument being this costs a lot of money if we don't do something to reduce recidivism. the national spending on corrections has gone from $9 billion in 1982 to $60 billion in 2002. So you have reform programs like the Justice Reinvestment Program. And this is a program that basically says to states, look, you can respond to your budget crises by reducing your correctional costs, by letting people out who shouldn't be in jail, by reducing the time that you put them under probation and parole supervision, and you can save a lot of money. And then you should reinvest some of those savings in the communities from which so many of these people come and to which so many of them will be returning. And if we can invest in those communities in ways other than police and prison facilities, maybe we can begin to solve this problem instead of just spending more money locking more people up. Now, this is, I think, a great idea, but the greatest thing I think about it is who sponsors it. Not the Open Society Institute. Well, actually, the Open Society Institute does, but it is sponsored by the Council of State Governments and the Justice Department. So when the Council of State Governments and the Justice Department are talking like that, that's, I think, an important area of reform. Death penalty. Death penalties have been dropping consistently for the past, I don't know, 5, maybe more years. We've seen moratoriums in many states. We've seen death penalty declared unconstitutional for juveniles. And the arguments that are driving this movement against the death penalty are arguments about risk of error, innocence, arguments about the technology of death, lethal injection, arguments about U.S. standing in the world, where most of the world sees the death penalty as a human rights violation, and we're still engaged in it. The last area is felony disenfranchisement, where a significant amount of progress has been made on reversing the practice of depriving convicted felons of the ability to vote for the rest of their lives. Here, the argument does often point to race, the fact that this disenfranchises a vast proportion of the black male population in many southern states. But even here, I think there's a subtle, often unspoken, broader claim, which is to Democrats who have traditionally received more of the minority vote than the Republicans. So, with the exception of the race claim in the felony disenfranchisement context, what all of these reforms have in common, it seems to me, is that they are race neutral, although, of course, as Vanita suggests, they have racially beneficial effects for African Americans and class beneficial effects for the poor, because that's who's locked up. But they are driven not by arguments about racial injustice, but by arguments about the state budget crisis, arguments about effectiveness, particularly in dealing with the drug problem, arguments about the importance of having individualized justice in terms of the attacks on mandatory sentencing, which are led by conservative stalwarts like Paul Cassell, and in the death penalty, questions about everything other than the racial disparities in the system. So I think the political lesson that one, and the other thing that unites all of these is that they don't come through the courts. They come through the political process. And I think, so the political lesson to me that one draws from this is that when one shifts from the courts, where equality claims should have had purchase but didn't, to the political arena, the arguments have to change to some extent. You have to appeal to the interests of the majority and talk about cost, talk about effectiveness, talk about community, talk about security. I'm not advocating, I will be the last person to advocate abandoning a focus on the fundamental injustice of the race and class disparities in the criminal justice system. Because actually I think one of the interests that we all share, no matter what our color, no matter how rich or poor we are, is a commitment to equality. And I think we need to constantly call the American public on that commitment. But it seems to me that those calls are most effective in the political arena when they are coupled with reforms and arguments that speak more generally race-neutral concerns. Thank you.
Thank you, David. That's really a lot of food for thought, and I'm going to open it in just a minute to questions from the floor, so have your questions ready. There'll be a microphone available for you. I just wanted to raise a point, just really a historical point, and I think to some extent David's comments may have answered this, but I think it's worth noting. You might think from what all of you said that, you know, racial disparities are sort of a persistent and intractable kind of fact of American life, deeply embedded in our history, and something that it's going to be very difficult to address and repair.
It's sort of my point. There's arguably greater income disparity in this country, and in general, there's been increases in crime. Now relative to 60 years ago, and that tends to affect the populations, the poorer populations, more than the more affluent populations. So I would argue it's social factors that don't really have to do with race.
I don't know. It's always this fact has always puzzled me as well. I do think that one possible explanatory factor, and I'm not actually aware of people who've tried to kind of test this out, but is the increasing concentration of urban an urban underclass, particularly in the Northeast. And one of the reasons I suggest that is I recently saw actually the Sentencing Project recently put out a study on racial disparities state by state across the country in incarceration. And one of the striking things was that some of the worst racial disparities are here, well, not here, are in the Northeast. I still think I'm in the Northeast. Are in the Northeast. Not in Texas or Louisiana, but in the Northeast. And I think that may in turn be in part related to this incredible concentration effect of the urban setting, where there are very, very few opportunities, and we have responded to crime in those communities in ways that just further destabilize those communities and create even more incentives for crime.
Yeah, I mean, I agree with that. I think also you can't downplay the role of the war on drugs, which really was a war on African Americans and Latinos and in these communities. It is, where police officers are deployed. If you look at the National Institute on Drug Abuse and the statistics about who's doing drugs, African Americans comprise 13% of monthly drug users, but they're 70% or more of people who are incarcerated, who are prosecuted and incarcerated for drug possession, just even the possession, right? Where are all these white people who are doing these drugs? They're not in prison. So, it's how we're dealing with that issue in these communities, and where police officers are deployed, and police officers being used to handle problems that in white communities you would never dream of calling police officer, like a 6-year-old in a school, or and I just I had this debate with a black prosecutor, by the way, and basically she said, well, black people do their drugs on the street. White people do their drugs behind closed doors. And I'm thinking, but the crime is possession of drugs. It's not possession of drugs on the street. And she, and then she gives me the Fourth Amendment argument. But anyway, we can't go into white people's houses and lock them up because it would violate the Fourth Amendment or whatever. But the point is how we're dealing with these issues. And we use police officers to deal with a lot of social issues in black and brown communities. And we don't deal with them that way in white communities. Everything from mental health issues to drug problems to school problems, you name it.
I just want to really quickly dovetail with what Angela just said. I also think that prison is a business now, today, the way it wasn't, and maybe even in the pre-civil rights era. And I don't think that it can be understated the degree to which there is really a prison industrial complex in this country today. Prison expansion is, and it's directly related obviously to the war on drugs, but private prison corporations are making enormous amounts of money from this. And to me, it's you build them and they will come. And what we're seeing now is that as sentencing regimes and alternatives to to prison sentencing is hopefully increasingly on the rise, at least in certain states. We are seeing this now transfer to immigration and immigration detention, where CCA, the Corrections Corporation of America, I'm currently litigating a case right now in Texas where this is the case, is increasingly having contracts with Immigration and Customs Enforcement to now detain immigrants and to have, we are now seeing what we saw in the war on drugs, which is that there is thousands, tens of thousands more immigrants currently in detention than there were even 5 or 10 years ago, and part of that is that there is an industry around prisons and the trafficking of human beings through that, and there is, rural economies in a lot of parts of this country are dependent upon this industry, and so it is, to me, what's going on today. It's a very different kind of prison scene today, even than what it was before, where there was more of a concept that this is really in the realm of government, that government and the state or the federal government needs to be administering prisons. We're in a very different era today, and I think that there's a for-profit motive also in the rise of prisons, and we're seeing it in immigration detention today is just as good as an example.
I should also point out that I actually agree with you, Angela, on the drug issue. I mean, it goes without saying that the explosion in the prison population is largely due to the drug laws. And again, as a libertarian, if it was up to me, there'd be no drug crimes except for selling to children. But given that there is, the crack versus cocaine distinction is absurd. It's probably as ridiculous as the alcohol versus marijuana distinction. As for the street crime, of course that's ridiculous, that if you use it on the street. Again, I would probably disagree with you that that's because of race. I mean, look at prostitution. At least based on what I see on TV, street walkers are, arrested, 25 times in a year, and from what I see in the yellow pages, you can carry on a prostitution business out of your home, an escort service, and they pretty much leave you alone. But again, I would argue that's probably not race. I would argue that's very much a class thing. The politicians who use the escort service don't want to upset that. But in any case, I largely agree with you.
Let me just ask one question about strategy here, and this sort of picks up on something Vanita was just saying about the sort of prison, the financial incentives for prison, which I think cuts against some stuff you said earlier and cuts against some of the proposals sort of all the way down the line. There seemed to be a profound kind of disillusionment with the courts, and David was very explicit about this, with court-centered approaches to dealing with the racial disparities, and Vanita spoke about the tragedy of McCleskey, and Angela talked about Armstrong and other cases that make it hard to bring directly equal protection challenges under the Constitution, at least in federal courts. And all the way along the line, we've talked about kind of appealing to common interests in the political system, to financial interests, to interest in addressing recidivism. But just to be provocative, do we really have much hope that the political process is going to be the place where we're really going to find the answers? Or to Angela, within the prosecutor's offices, within the Department of Justice, or within the executive branches in states, or within local police departments and local district attorneys' offices, that's where the answer is going to come from? I mean, were we really wrong to think that the courts were the place to go? And right now, is the answer, should we turn our energies primarily to retail arguments in the political sphere? Let's find the poster children and say we've got to do something. Should we turn it, to the interests of sort of the white majority in saving money and in preventing recidivism? Or should we appeal, for example, I agree that the federal judiciary right now is not a promising place to go, but if a lot of the problem, David, is in the Northeast, why don't we appeal to state courts? And ask them, New Jersey, Massachusetts, these aren't bad places to go with these kinds of claims. So where should we go to fix this exactly?
Well, I definitely don't think we should go to courts. I don't. Maybe on some states, in some state courts, but definitely not the courts for all the reasons I mentioned before. I don't expect prosecutors out of the goodness of their hearts to suddenly see the light and all that. No, I don't think that. I mentioned the 2 projects I'm working on because I do think that when there are well-respected prosecutors who are respected on the national level, who take leadership in the NDAA, National District Attorneys Association, and other groups, showing that kind of leadership, I think that can make some difference. I'm not saying that's the answer. But I do, when I say the political process, I didn't say it before, but when I'm talking about political process, a lot of times it comes from, the same, reasons why legislators pass laws, which are bad reasons. As someone mentioned, a high-profile case happens in the media, and then there's Megan's Law, there's Polly's Law, there's David's Law, there's Angela's Law, They name these laws, and then they put very little thought into it, and they march for it like they did with the drug laws and all of that. But sometimes there are high-profile cases that can make a difference in ways that I think can be helpful to what most of us on this panel are trying to promote. When people do see, stark disparities, it can have an effect, for people of color. I often talk about, the Mike Nifong situation, where, here, we have these, rich white boys who are victims of prosecutorial misconduct, and then this great outrage by the state attorney general saying, Mike Nifong hid evidence and didn't turn it over. Well, everybody who's a defense attorney in this room and in the world laughed out loud and said, "Are you crazy? This happens every day to poor people and people of color." That is, people are victims of prosecutorial misconduct. Prosecutors are, well, it's Saturday, so maybe they're not right now somewhere withholding Brady information. If they're working on Saturday, they are. It happens every single day to poor people, at mostly black and brown people, but their lawyers can't hold a press conference that's breaking news on CNN and announce that it's happening, and their clients are not wealthy lacrosse players, so no one cares, about them. But as a result of what happened to them, I do think now that prosecutors are going to be scared, I think, because they don't want to be the next Mike Nifong. So I think that the public has become aware. I guess what I'm saying is when the public becomes aware of something, and it strikes home to them, and I think that struck home to them when they saw these 3 kids that looked like their kids and what happened to them, then they might think about, we got to reform the way prosecutors are behaving. We got to do something about this. We got to open the doors. So I think we have to take advantage of those moments in time, to make them have an effect for the broader community and for most of the people who are affected by these problems, which are black and brown people disproportionately in the criminal justice system. So I'm not naive, but I am somewhat hopeful along those lines that it can be used in that way, and that the people can then press their state legislators and others and their policymakers and their prosecutors, who are, after all, elected officials, that maybe the next time they'll ask them some questions and, before they vote for them about what they're doing. So I think we can't give up on that process. I don't think that it's going to change the world, but I think it's better than the courts.
Yeah, I would add that it is largely a matter of public opinion. The political process has been very helpful in civil rights. I mean, just look at, Title VII, both its passage and expansion. That depended on the political process, and certainly the American people in the last 40 years have come around to the idea that discrimination based on race is wrong. I'm not saying everyone follows it, but at least it's now an ethic in our society. The problem is that public opinion also feels increasingly, unfortunately, that anything that sounds like leniency in the criminal justice system is, your cute little kid is going to endangered by it. So I think that sort of overrides the ethic, and the chance that sympathy for criminal defendants is going to increase anytime soon, I don't think is likely. So again, it's hard to know where the solution is going to come from.
But if they think it could happen to their kid like it happened to the Duke kids, they might get a little scared. They don't care about the black and brown people, but they care about their
yeah,
kids.
no doubt. Just watch the news. I mean, it is, the cute little white kids who they, have this incessant coverage of when they get kidnapped.
That's
No doubt
right.
about it.
I think that the traditional view in criminal justice was that this is an area where you can't rely on the political process, that the problem is the political process, that criminal defendants are the other than the ACLU, they don't have a lobby. And so what do? You just try to stop Congress from acting as much as you can. You try to get courts to intervene. And, lo and behold, at one period in our history, courts did. The Warren Court intervened consistently to expand the rights of criminal defendants. But what I think is important to keep in mind about that was it did it in a context of a significant civil rights movement around racial justice issues. And and that's the only time that the courts have really responded, is when there was a significant political movement. And I think today the notion that the courts are going to do very much is quixotic, and that really our only opportunity is in the political process, which is not to say you don't bring cases. Cases can sometimes be very useful as political organizing tools, and to tell the stories that Vanita was talking about, so that you can then push for political reform. But in each of these areas, all the areas I identified, the advances have been political. And we titled this panel Beyond Racial Profiling. If you look at the racial profiling progress that was made and then apparently stopped on September 11th, 2001, all of that progress was made through legislators, through cities and counties adopting reforms, not through court cases. The court cases on racial profiling were for the most part, a bust, but the political reform was significant. So I think that is where we have to be, and then you have to think, given that that's where we have to be, what are the kinds of arguments that are going to be most effective?
Anita, I was going to we have just a few minutes left, but if there were questions or comments from the floor, Anita's raring to say something.
No, I'm fine. I'd rather get questions.
There's a microphone. Sarah, are you here? Yes, Sarah's got a microphone, and we have a question up here.
I was struck by the agreement between all the panelists on the futility. I was struck by the agreement of all the panelists of the futility and the bad policy of the war on drugs. When Milton Friedman died last year, I pulled up a letter he wrote to George H.W. Bush in 1989, predicting exactly what has happened from a libertarian standpoint. We'd triple the prison population, quadruple the cost of drugs, and make us less secure and take away our liberties. If everybody here agrees that we should do away with the war on drugs, is it politically and pragmatically possible to convince the political branches to do that? Because it seems to me there's widespread agreement amongst all of you that the war on drugs has been a total failure. The second victim after the minority community, by the way, of the war on drugs is the federal courts. And when you talk about drug courts, we're already a drug court, okay? So we got drug courts. There are 94 judicial districts that are drug courts.
By the way, when we're talking about agreement between libertarians and liberals here, I think the federalization of crime is another thing where we can agree. Certainly a lot of conservatives think Congress has no business, just repeating all the same statutes, or I shouldn't say the same statutes, but criminalizing all the things that already were criminal at the state level, and often, with harsher penalties, and you have to deal with the sentencing guidelines. Because, again, it's very politically popular. I mean, congressmen, what better thing to run on than, you're fighting crime.
I think that there's a lot more movement going on in the states. I'm a lot more cynical about federal reform, and obviously maybe 2008 will change that for me. I'm not sure that it will, because actually President Clinton didn't do anything about mandatory minimums, and so I don't know how much that really has an impact. But I think there are a lot of things going on at the state level, and to the extent that you were talking about giving up on the courts, I also think that the few victories that we do have in the courts are from state constitutional litigation around, the New Jersey Constitution has a much beefier equal protection clause. There are a few state constitutions that do give meaning to those. And I think that, you know, we'll see what happens when Congress changes, but when the political, in 2008, if there really is a lot of energy to look at criminal justice. But I'm not holding my breath on that. I do think there is significant reform right now that Congress is considering, even as to crack cocaine reform, but it's taken so long, and we'll see if that happens. And there's still about a retention of a 20-to-1 ratio, which still to me seems problematic. I don't, you know, so we're headed in the right direction on that. But to me, I'm looking at the states, and I think, you know, sometimes the best criminal justice reform happens at a local level, and ultimately maybe there'll be enough movement in enough states that will ultimately push the federal government to do what it needs to do, especially around mandatory minimums.
I just think on drug reform that it depends on what the drug reform is. So legalization, I don't think, is really in the cards, but treatment alternatives, I think, is a much more sellable remedy at this point.
I think we have time for one more question or comment. There is. Here we go. Yes.
I was interested in having, well, anybody can address this, but bringing in the aspect of juveniles in this, because as you point out, the school to prison issue is big. I actually taught in the DC public high schools last year as part of my law school curriculum, and I think that's one of the biggest issues that DC is maybe starting to address, is the role that the Metro PD play in the public high schools. And I'm just curious to see how the role that bringing the juvenile aspect or perspective into this, how reforms can be made, because I think that the juvenile aspect really raises the issue of all of the other social issues that play a role in why we are where we are when you look at who's walking in and out of prison every day. So I'm just wondering if there somehow in the criminal justice reform effort, like what efforts are being made to look at other social issues, and in terms of prosecutorial discretion and sentencing, especially when you look at juveniles and they have hopefully so much ahead of them, and a lot of that hope is dashed quite early. I also worked with a juvenile my first year of law school who had been in and out of the Oak Hill juvenile system. He was 17 5 times already. So just to maybe address some of that and how that can kind of give us a perspective on where these reforms could go and where they'd be most useful.
I mean, I think that to me, the school to prison issues actually are incredibly important, because I think they are a direct feeder into the system. But in looking at juvenile justice in particular, in fact, when I'm talking about indigent defense in the adult criminal context, indigent defense for juveniles is like, it's just, it's horrific. It's at a level that it's you know, and there are a lot of great reform advocates that have been trying to establish standards, but there's so little oversight in the juvenile justice area that I think it's a huge problem. I do think it starts a lot earlier. It really does start about criminalizing what were before minor school discipline problems, and criminalizing them and involving the juvenile justice system in the schools for those. I'm not denying that there are public safety issues that people need to be concerned about in schools, but that as Angela said, there's a tendency in this country to, and probably not just in this country, but to rely on law enforcement to address the problems going on, what are clearly social issues, what were considered social issues, particularly in school discipline arenas. And there are principals and teachers and school administrators who just feel completely disempowered against the increasing infraction of law enforcement and police. And I think, part of it, I talked about some of the ways in which people are now challenging. A lot of it is at individual school levels but you need lawyers who are able and versed to look at, who are versed in juvenile justice, but who also know how to deal with school administration and school suspension and school expulsion. This is a whole area. It doesn't seem very sexy. It doesn't seem like what any of us went to law school for, because it's very direct services. But a lot of kids who are confronted with these problems literally have no representation enforcement at that level in schools, and the lack of representation directly feeds. And once you're in the juvenile justice system, there's 1,000 ways for you never to get out. I mean, it's the easiest because it's considered still rehabilitative, but they impose all of these rules about not going out after 7, about not being on the subway. I mean, there's 1,000, and it's a real downward spiral. So I think there needs to be, and there is now, a growing examination of what's going on at the schools themselves to try to address kind of the funnel ultimately into dropout rates and prison.
Yeah, I think this somewhat ties into the last question. We all agree that there's virtually no reservoir of sympathy or even sensitivity for adult criminal defendants, but I think there is still a reservoir for juveniles. I mean, that perhaps one can leverage that to, in general, work reform into the system for at all ages. Unfortunately, I worry that even reservoir sympathy for juveniles may disappear. I mean, we do see sort of, at least in the popular media, the idea that, a 13-year-old can be a hardened criminal is sort of taking hold. I mean, the Supreme Court has been somewhat helpful there with the death penalty, but certainly in public opinion, the idea that, a 12-year-old or a 13-year-old can be almost as bad as an adult recidivist is unfortunately taking hold. But again, there's still a reservoir there that we can work with.
I think there's not a reservoir of sympathy for black juveniles. I think they're seen as dangerous, and people don't care about black kids. I think they care about white kids, but not about black kids. But those of you who don't know about the Jenna 6 in Louisiana, anybody heard about the situation? The photographer has. Okay, great. And some people have, where these white kids in this high school there in Jenna, Louisiana, made these little nooses and hung them around the school, as in lynching. Obviously created tremendous tension. The black parents complained about it. The white kids got a few days suspension. The black kids and parents were very upset about it. Lots of fights going back and forth in the school where the white kids were involved in the fights and the black kids. Nobody was prosecuted except the black kids, and now one of them is facing a 10-year mandatory minimum sentence for being involved in that fight in the school where there weren't even significant injuries. That's just one example.
For attempted murder.
For attempted murder. So, I mean, I don't see that sympathy for black kids, for black juveniles, unfortunately, and I think that's why, we've got to sort of, those of us who are, not directly involved have to care about these issues and speak up about them, and, that's the challenge to each of us, I think.
Yeah, I was going to be the Jew in Berlin and say also that, the Supreme Court got rid of the death penalty for juveniles, but on the heel of a lot of legislative action that got rid of the death penalty in individual states only because there's now mandatory life imprisonment without possibility of parole for many juvenile murderers. So, it's not everything that looks like, this is one of the things on David's list that looks like progress, but it looks like progress through one lens, but perhaps not through another. Anyway, before I thank, and we all thank our distinguished panel, I have two important announcements. One is that this afternoon, Angela Davis will be signing her books right out here in the registration area, 3:45 to 5:15, so you too can own a copy of Arbitrary Justice, 3:45 to 5:15 right out here. And to everyone here, please join us in just 15 minutes at 12:30 this afternoon for lunch and a panel discussion on covering the courts. And lunch will be back in salons 2 and 3 of the ballroom upstairs. May I ask all of you to join us in thanking this terrific panel.